The representations in the media are that the Crown has purchased 10 million of these vaccines, and so if the Crown has purchased them already, it may not affect Pfizer anyway. That was my interpretation.
It's the actually trading act table, reputation, isn't it?
I guess that's...
Yeah, so I think you do need to, and I'm assuming they have a New Zealand office.
That their applicant was a New Zealand applicant.
Okay, so you need to do that. I'm beginning to think that until those things have happened, until the Crown's had a chance to see the shape of the amended application, it might be a bit premature to make any other directions.
The difficulty on it is that as a result of the announcement by the Prime Minister about a week ago, she told people basically not to come to work if they hadn't had the vaccine. And this is why it went from being of considerable concern to of being extreme urgency on it. And I think she's postponed it. It's a bit of a Fitzgerald and Muldoon type situation, as I can't find any law supporting what the representations have been, but it's created an enormous amount of angst and employment issues, health and safety issues.
Well, I imagine I've got no idea really, but I would have thought the reality of that is that it will depend on people's employment relations. Well, I've got a memorandum in support of an interloctory application, but I see. So it was under the wrong tab. I mean, under the right tab, but I didn't see it. I see. Oh, that probably isn't the application for a convenience, then, is it? That's great.
So, well, it was intended to be one.
Sure. Okay. I see. All right. No, thank you for that. So, Ms. Gorman.
Yes.
As you say, we just need to progress this.
Yeah, well, there are a few preliminary points could I make about the application. So this relates to a decision that was made in February this year.
Yeah.
And the respondent's submission is that the plaintiff hasn't demonstrated that this needs to be heard in an abridged way. And there are a number of issues raised by the claim in terms of standing, justiciability, and the role of the court. And
right. Sorry, that's right. Right things down. Yes, well, I've already referred, I suppose, in one sense to the role of the court, and that was one of my concerns about the aspects of the claim. But when you say, I think you said abbreviated or abridged process.
Yes, with some of the orders sought, Your Honour, and not certain to the extent to which those we dealt with today, that are for the abridgment of time for filing a defence.
Oh, sure. Let's proceed on the basis that it's an application for interim orders. In which case, so a statement of defence, I think, is not required.
Correct.
It would be a notice of opposition.
Yeah. In terms of the application for interim orders, I've raised with my learned friend the need for this to be served on the vaccine manufacturer, who was the applicant for the consent that's under challenge. So I think...
yes, well, that looks really complicated. That's Phizer, isn't it?
That's right. The orders sought do not accord with Section 15 of the Judicial Review Procedure Act, particularly subsection 3. They're not seeking declarations, Your Honour, they're seeking, for example, directing the Crown to stay the rollout of the vaccine, directing that the approval as in it, Your Honour, law, directing that claims are misleading, directing the Crown to prepare and circulate correcting information. So I was going to propose, Your Honour, a timetable that enabled the plaintiff to revise the interim orders application, serve it on the manufacturer, give sufficient time for the Crown to file an opposition and support an affidavit. But I haven't heard yet, Your Honour, a proposed timetable from the plaintiff.
No. It would be, in terms of interim relief, the first interim order sought directing the Crown to stay the rollout of the Pfizer vaccine. In theory, that is a relief that could be sought in an interim order.
I think it would need to be reformed into a declaration.
Why?
Because section 15(3) of the Act says that when the Crown is a respondent, that...
Oh, yes, I see what you mean. Sure, yeah, sorry, yes. But a declaration of that effect is something that, in theory, yeah. And
there was also, Your Honour, part of the grounds on which the order is sought include that the ground D, that the Gazette notice fails to specify that the vaccine is prescription only. I have advised my group provided you with the Gazette notice that does specify that the vaccine is prescription only, so I just presumed that the plaintiff may wish to refresh the application.
Sure. I would have thought, for interim purposes, the focus would really have to be on section 23(1), myself.
Yes.
So you agree with that?
Yes.
I think, yeah. All right, I'll just talk to Ms. Gray. Do you agree with that, Ms. Gray?
I certainly agree, section 23(1), Your Honour, and I have noted what my friend has raised about the prescription only issue, although it's a bit of a hybrid. The notice is prescription only except approved vaccinators, and the vaccinators, as I understand it, are people who have done a 2-hour online training course and don't necessarily have any medical training. So although it seems to be a new category, I hadn't found that Gazette notice because it's listed under a general heading rather than under the same product name.
Right.
But I do accept that it exists.
All right, well, it might be useful if you could, I don't think it would take very long, if you could amend your application, and as Ms. Gordon said, because the respondent is the Crown, it's only declaratory relief that you can obtain, so that you just reflect that, and perhaps just focus on what can, because at an interim stage, this is simply no way any sort of merits-based consideration could be given.
I do understand that, Your Honour. Just in relation to the allegations of misleading deceptive claims by the Crown, that the vaccine is safe and effective, there is subsequently some documents that have been published by the Crown which make clear that the Crown themselves didn't believe the vaccine was safe and effective and had been sufficiently tested. So I don't believe it would take a long time to raise. It's a Medsafe minutes published on the 30th of April, so just a few days ago, but it was actually from the meeting of the 20th of January, so a week or so before the Gazette notice.
Yes, I suppose strictly speaking, the Fair Trade, we don't normally combine judicial review and the Fair Trade Act courses of action, so
I understand that, although I do have a precedent that went to the Supreme Court, but not on an issue, but on the Saxon case. And we had the High Court proceedings involved judicial review and tort claims and fair trading.
right, although what went to the Supreme Court?
It wasn't that issue about whether it was possible or not. I think it was the matter with Justice Hammond at the time who was happy for them to be dealt with, where there's a remedy type aspect, Your Honour.
Although possibly not on an interim basis. So just one, I just got to ask Ms. Gorman one more thing. So what's the standing issue that you refer to?
Well, it would depend, Your Honour, whether it's raised on an interim basis, depending on what the focus of the interim orders comes to be. Because in terms of the rollout decision itself, there's no suggestion, as unsaid by the plaintiff, that she's representing people who are currently entitled to receive the vaccine under the first two groups who are eligible.
Well, there's not. All right.
I mean, it's quite complicated. There's a wide number of claims, and I mean, as was Grace referring to, there is a bit of cherry picking in my submission going on in terms of the information before the court. We do need time to prepare affidavits that show that, give the court the information it will require. going to assess any of these claims.
If we're going down the interim route though, obviously it's not going to be by definition it's not a full-blown. I'm not saying you can't find evidence, of course you can.
Yes. Well, it'll just really depend on what the revised application looks like, Your Honour.
Alright. I think well, that's great. I think the first step is for you to file a revised application, and the more focused it is, I think the more likely you will be able to get it on quickly, because the more time the Crown needs to respond, obviously, the more time will be directed. So, how soon, when do you think you can do that by?
Today, Your Honour.
Alright, so...
and Your Honour, I also do have a third affidavit that is prepared, almost ready for filing. This is one that actually had to be attached, and that is from a person who is in Group C, a person over the age of 65, and he's in Group C, and his mother is in a rest home, so there are issues about the rollout of vaccine to them based on the presentations made to the occupants of the rest home and their caregivers. It is a complicated matter, Your Honour, but I'm concerned that the suggestion there's no standing. The plaintiff represents, I don't know who the plaintiff represents anymore, Your Honour. Well, I know it represents the applicant, the plaintiff, Your Honour, but I've been absolutely swamped with emails from doctors, pilots, nurses, people in old folks' home, people who've been threatened with losing their jobs. It's
presumably though not members of the society.
Well, people that are joining the society, as we speak, Your Honour, a website and special email addresses had to be set up because of the significant interest in this matter.
Okay. Right, so anyway, you can file and serve an amended application today, and further affidavit what, tomorrow?
Today was not all
Today. I suppose to some extent the Crown's what the Crown will need to do in response will depend on the application you file.
Yes, Your Honour. I'm happy to say that I won't proceed with the prescription issue for the sake of that it's prescription only, Your Honour, for the sake of expediting the first part of the hearing, first issue. But it is my submission that the matter of the misleading and deceptive claims that an untested novel vaccine is safe and effective is a matter that needs urgent judicial overview.
Yes. I mean, that's your free training that claim, right?
Yes.
So strictly speaking, that would, if we were to apply for interim relief in relation to that, would be more in the nature of a I don't know, think about that. I do think that is going to blow things out. That's all, in terms of and of course there's the matter that Ms. Gorman raised about having to sue Pfizer. So are you able to do that?
Yes, I can certainly, although my submission is this is a Crown decision.
Sure, but you're affected.
Yes. And
I mean, if you get what you want, there's a huge effect for Pfizer, isn't there?
well, the representations in the media are that the Crown has purchased 10 million of these vaccines, and so if the Crown has purchased them already, it may not affect Pfizer anyway. That was my
Well, certainly if you're trading that claim would, reputationally, wouldn't it? Yeah, so I think you do need to, and I'm assuming they have a New Zealand office.
That their applicant was a New Zealand applicant.
Okay, so you need to do that. I'm beginning to think that until those things have happened, until the Crown's had a chance to see the shape of the amended application, it might be a bit premature to make any other directions.
The difficulty, Your Honour, is that as a result of the announcement by the Prime Minister about a week ago, she told people basically not to come to work if they hadn't had the vaccine. And this is why it went from being of considerable concern to of being extreme urgency, Your Honour. I think she's postponed it. It's a bit of a Fitzgerald and Muldoon type situation, as I can't find any law supporting what the representations have been, but it's created an enormous amount of angst and employment issues, health and safety issues.
Well, I imagine I've got no idea really, but I would have thought the reality of that is that it will depend on people's employment relations, whether or not that actually gets carried into whatever. And it's really an employment matter, isn't it?
Well, it's a result of the representation by the government saying basically don't come to work if you haven't had if you can't prove you've had the vaccine. And my client submission is that first, there's no lawful basis for that, and secondly, it's contrary to the approval that was granted, the provisional approval, and thirdly, to basically require people to have a novel, partially tested vaccination under duress of loss of their employment is hard to imagine a more urgent matter.
That is in your statement of claim as it is at the moment, isn't it? That don't come to work.
I think so, Your Honour, although the statements by the government have been coming pretty fast and we've sort of had to draw a deadline on.
Okay, well, there I suspect you might have a standing issue unless you have people, unless you're going to add some plaintiffs who are actually directly affected by that, so that's something else you could possibly
I have people queuing up to plaintiffs, Your Honour. I was trying to keep it as simple as I could, but that we need to do that.
All right, well, all I can really do, I think, for now on this raise is I make those directions that you do those things. I'm happy to have to call a telephone conference later in the week where we can talk about some further directions. I don't think I can do any more today because a lot does depend, as they say.
Yes, Your Honour. Would it be possible to identify a potential hearing date, Your Honour, and then we could sort of work towards that?
Well, what sort of hearing date did you have in mind?
Well, the idea would be a day, Your Honour, but...
sure, no, I mean...
sorry. Within a week, Your Honour.
Yes, I suspect the Crown would say that is not... Well, again, depending on how narrow compass is, I suspect they would say that's not doable. What I can offer, and again, obviously this may not be doable for the Crown either, I think was the 5th of May. I just need to check my notes. Yes, 5th of May.
Mr. How did the Crown agree to postpone
Well, you can have some offline discussions, but I suspect the answer, I know the answer.
No, I mean, it's very difficult to know what evidence the court is going to require because we don't know what the scope of the orders.
Understand that. Well, look, I think the best I can do for you is great is we'll have the telephone conference later in the week. I've put that 5 May date out there. That may be possible, depending. So, in a sense, it's up to you as much as it's up to the Crown.
Is that a half day or full day?
That whatever is required. I mean, as I say, my own view is that if it's just a Section 23(5) issue, that's really quite discreet and could be dealt with quickly. I suspect. Might be wrong. Anyway, well, we can talk about that anymore. When suits for a telephone conference, probably may as well be with me because, well, I've got to talk to this extent. I can't do Wednesday, but I could do Thursday, possibly.
Yes, Your Honour.
Yes, I think we would if Pfizer could have the opportunity to do that.
Oh, true, yes, good point. So if you could, can we make it Thursday 9 a.m. And if you could, when you serve Pfizer, can you tell them about the telephone conference?
Yes,
And I'll send out a minute so you can provide a copy of the minute too. All right, that's probably all I can do today this way. I'll make the directions that you're going to file an amended application together with a further affidavit. I think you do, well, depending on how wide your application is, you have to think about plaintiffs standing. And that you're going to serve as well as suing the Crown again, suing Pfizer, and we'll have that telephone conference on Thursday.
Thank you.
Right, thank you.